On behalf of the Buxbaum Lectureship Committee and all of us at Drake University, we are very pleased that you've joined us on this rainy evening. I would like to begin our event with some important acknowledgments. First, please join me in thanking the Buxbaum Committee, whose guidance and energy over the years have made the Buxbaum Distinguished Lectureship a major event in the Central Iowa community. Their names are listed in your programs, and I'd like to ask our committee members to please stand up and be recognized. I'd also like to express great appreciation to Erica Hartchen, the coordinator of the series, for all her hard work and effort. Erica is backstage, but why don't we also give her a nice round of applause, please. This event, of course, would not be possible without the generosity and support of the late Melva and Martin Bucksbaum. Mr. Buxbaum was one of Iowa's most successful business leaders. He was chairman and president of the General Growth Corporation, a leading retail development company. He also served for more than 15 years as a member of Drake's governing board. Mrs. Buxbaum, who passed away earlier this year, but before her passing, she was instrumental not only in the establishment of the Buxbaum Lecture, but also in its growth and future. She and her daughter Mary made a generous gift to expand the lecture's impact well into the future. The Buxbaum family has truly left an important legacy here at Drake University. As you can see in the program, we have hosted extraordinary speakers over the years, and I've been told that there are many in the audience tonight who have been attending every single one of those lectures. Welcome back. This lectureship was designed to bring people of international stature to Drake to deliver a major address on such issues as those affecting business, health, the arts, politics, law, and international affairs. The lecture is our most powerful and enduring event in fulfilling the university's social compact, that is, to serve as a place where the community comes together to discuss, consider, and debate the vital issues of the day. Tonight's speaker has kindly consented to answer audience questions at the end of his remarks. He'll take about 15 minutes for that. There are microphones located on either side of the floor, and so at the allotted time, if you would like to ask a question, please raise your hand and one of our student volunteers will indicate when it is your turn to get in line. Please do not get in line unless instructed to do so by one of our student ushers. Also, if you ask a question, please make sure it is a focused and brief question rather than a monologue. We'd appreciate that. If you have any device that might ring or buzz or otherwise call attention to your presence in the audience, I'd ask that you please ensure it will not do so until after the conclusion of our event. Now it is my great pleasure to introduce to you tonight's distinguished speaker. Peter Neufeld is the co-founder of the Innocence Project, a national nonprofit organization that seeks to exonerate wrongly convicted inmates through DNA testing. The Innocence Project represents inmates seeking post-conviction release through testing and pursues institutional reform to identify and address the systematic causes of wrongful conviction. To date, the project's work has resulted in more than 300 people being exonerated through DNA testing, including 18 individuals who served time on death row. Mr. Neufeld is a partner in the New York civil rights law firm of Neufeld, Scheck, and Brewston, where he focuses on constitutional law and police misconduct. Mr. Neufeld has provided pro bono services to dozens of lawyers representing accused in death penalty cases. He has lectured and taught students, lawyers, judges, and legislators on subjects at the intersection of science and criminal justice. Before co-founding the Innocence Project, Mr. Neufeld taught trial advocacy at Fordham University Law School. Please join me in welcoming Peter Neufeld to the podium.
Good evening. During the summer of 1981, Catherine Schilling was an undergraduate student at Georgetown University in Washington. She had a summer job between her junior and senior years, working for a prestigious law firm in the Watergate office building on the shores of the Potomac, not very far from Georgetown. On the evening of June 21st, after leaving the law firm at about 9 o'clock in the evening, she walked about 100 yards down the road and then cut into Rock Creek Park, which is a very narrow strip of land running between downtown Washington and Georgetown. She was going to cut across Rock Creek Park Bridge to get home to her apartment in Georgetown. Ms. Schilling never made it home that night. The next morning, the law firm sent out a search party, and after about an hour, they found the partly naked, dead Ms. Schilling by the banks of Rock Creek. She had been raped, and she had been shot repeatedly. This is the kind of case in America that we call a heater, meaning it's the kind of case that the media becomes very involved in very quickly. It's the kind of case where the chancellor at Georgetown University is calling the police and calling the press and demanding that the person responsible for this heinous crime be apprehended immediately. It's the kind of case where the senior partners at the law firm are calling the mayor and demanding justice. Of course, like so many crimes of this nature, it was late at night, it was dark, and there were no eyewitnesses. And what often happens in cases like this is that the police, not having a natural lead, not a husband or a boyfriend, okay, it's a stranger, they start looking at police records. They start trying to find out whether or not there were other similar crimes that occurred in the same neighborhood. And maybe if they're lucky, there's already a suspect attached to those other crimes, and they can investigate that person. And that brings me to a young man named Donald Gates. Mr. Gates was a young man who was born in Ohio, dropped out of college after a year, was in the armed forces for a few years, but he didn't do very well in the armed forces, and he developed a drinking problem. He was eventually discharged, and he went to Washington, D.C. He couldn't get regular work, so he was a day laborer. Worked from time to time, sometimes stayed in rooming houses, sometimes found himself in a shelter. And eventually, by March of 1981, he had a couple of run-ins with the law. Particularly in early March, he stole a briefcase from a room in the Smithsonian Museum and was apprehended immediately and arrested for that offense. And so a photograph of Mr. Gates ended up in the mugshot books at police headquarters in Washington. In any event, at some point in time, in March, a woman named Fitzsimmons was attacked by an African-American man in Rock Creek Park, less than a quarter of a mile from where Ms. Schilling was killed. And this woman was robbed and then raped. When she went to the police, there were no natural suspects, and the case went cold. After Mr. Gates was arrested in March for the handbag, for the briefcase case, his picture was shown along with a group of other photos to Ms. Fitzsimmons. She identified him as being the rapist. And so when the police first heard about the Schilling case and had no suspects, and they looked for similar cases, they immediately became fixated on Fitzsimmons. After all, it was another rape. It was in the park. Both incidents seemed to have started like robberies and then morphed into a rape. Of course, in the case of Mrs. Schilling, she was also murdered. And so the police had Donald Gates as a suspect, but only a suspect. They didn't have anything else to connect him. But that all changed about 1 week later. Because 1 week later, a kind of person we refer to as a jailhouse informant walked into the Washington, D.C. Metropolitan Police Department headquarters and said that he had read about the case in the Washington Post and that he had vital information to provide the police. Of course, to provide this information, the police would have to pay him, and they would also have to take care of a couple of outstanding criminal cases that he had at the moment. The police interviewed him, and he told the police that he had been drinking in a park when a man named Donald Gates came up to him and bragged that a week earlier he had encountered this white woman in Rock Creek Park. He intended to steal her bag, but then it evolved into a rape. And when he realized what he had done and that he could be apprehended, he decided to shoot and kill the victim. Well, this was very good for the police. This is, after all, the same man who was their suspect. And this would be a confession given to this informant. But there was just one problem, and the problem surfaced 3 weeks later. On June 30th, the informant came in and gave the story. 3 weeks later, on July 21st, Mr. Gates is apprehended. He's charged with the Fitzsimmons rape, and now he's also accused in the Schilling murder. But when he's picked up, they looked at his records very carefully, and they found out that on the day that Ms. Fitzsimmons was raped, Donald Gates was serving 30 days in jail for stealing that man's briefcase from the Smithsonian. He couldn't have committed the crime. It was a case of misidentification. But whereas they were able to clear up the Fitzsimmons mistake, there were no eyewitnesses to this murder. There were no other witnesses to the murder who heard anything at all. And so they had this informant, an informant who told them that Mr. Gates had confessed to committing the crime. But they were worried. They were worried because, after all, this informant was a sort of unsavory character. He was demanding money. He was demanding that his own cases be dismissed. They were somewhat concerned. They wanted more. And so what they did, which is what police often do in these kinds of homicides, is they look at the physical evidence. And as you all must know from watching television or seeing the movies, that when a crime like this happens, during the autopsy, physical evidence is collected. And in this case, a rape kit was made. Semen was collected. Hairs that appeared to be foreign to Miss Schilling were found on her body, and they were collected. And of course, the first thing the police did, of course, remember, this is before DNA testing, but the first thing they did was they tested that semen, but then they used what was called conventional serology. You may know it as ABO typing. And they did the testing, but what was often the case before DNA is that when they tried to do serological testing, they simply got inconclusive results. That often happened because you needed a robust sample, you needed a large sample. And as you can well imagine, crime scene samples don't appear in that condition. And so without serology, they were left with these two hairs. And they sent the two hairs to the FBI crime laboratory, the largest crime laboratory in America. And they asked the FBI to compare those two foreign hairs with hairs that they would then collect pursuant to a search warrant from Donald Gates. And he turned over about 50 hairs during the collection process, and those too were sent to the FBI. Some time went by, and the FBI contacted the detectives and said, guess what? The hairs, the two hairs found on Ms. Schilling's body match the defendant's reference hairs. They are very similar. And so now the police had exactly what they wanted, and so did the prosecution. They had a person who was saying that Mr. Gates confessed, corroborated by hair evidence from the FBI. The hair evidence from the FBI, which was not unique, it's not like a fingerprint or a DNA profile, because you don't know how many other people have similar hairs. Nevertheless, it was powerful evidence that would corroborate the informant. And so in the fall of 1982, Mr. Gates, who was indigent, but was assigned a very good lawyer to represent him, went to trial. And the two critical pieces of evidence were the informant, who testified about the confession, and the FBI agent hair analyst, who testified about the hair. But whereas in his report, where he simply described the two hairs as being similar to Mr. Gates's, in his trial testimony, he said they're microscopically indistinguishable. It is extremely unlikely that these two hairs came from anyone other than Mr. Gates, and I base that conclusion on the thousands of cases where I have examined hair while at the FBI. And so, in the fall of 1982, Donald Gates was convicted of this horrible murder, and he was sentenced to life in prison. And he was sentenced to life in prison initially in one of the worst prisons, a place called Lawton, for those of you who know D.C. Lawton was eventually closed down after a number of civil rights suits illustrated just how awful the conditions were in that prison. There were beatings by guards routinely. There were inmates who were recruited to do enforcement work for the guards by terrorizing other inmates. It was a terrible place. And Mr. Gates went off to Lawton. In 1988, there was a new breakthrough in forensic science. It was called DNA. And that was the very first year that it entered the marketplace in the United States as a crime-solving tool. As soon as Mr. Gates read about it in Time magazine, he contacted the judge who presided at his trial, and he asked that the crime scene evidence, the hairs and the semen, be subjected to DNA testing. The judge granted his request, and the evidence was sent out. But as you can appreciate, science evolves. And in those days, DNA was in its infancy. And so when the evidence was subjected to DNA testing, it simply came back no results. And so Mr. Gates resumed his life sentence in these horrible prisons. By 2008, 2009, there had been many scientific advances in DNA, and they were able to do DNA testing on much smaller samples, samples that were far more degraded, and they were able to secure very, very specific results. And they were able to test the semen that was obviously left by the perpetrator in this case. And when they did the DNA testing, after 27 years of imprisonment, Donald Gates was excluded as the source of the semen. And furthermore, they then subjected the results from that test to the National Convicted Offender Database, a database that was created in about 1994 as people were convicted of different serious crimes all over the country. Samples of their DNA were entered into the database and profiles were maintained. And they came back with a cold hit. And the cold hit was to a young man, well, it was a young man in 1981, who had been working as a temporary janitor for one night only at the law firm where Catherine Schilling was working. And that one night was June 21st of 1981, the night she disappeared and was killed. And so Donald Gates became one of the 333 people who have been exonerated through post-conviction DNA testing, including 19 from death row. Most of these people had served more than 14 or 15 years of their sentence before they were exonerated. Donald was an outlier at 27 years. We believe that these 330 people are simply the tip of the proverbial iceberg. Why do we think that? We think that because in most cases, there is no biological evidence for testing with DNA. Crime lab directors estimate that no more than 5 to 10% of the cases they work on have biological evidence. If you look at a case like this, you know, there was an informant. There could be informants like this, paid informants in lots of cases where there's no biological evidence. And so we were very concerned that not only would there be many other people out there who were wrongly convicted, but it became incumbent on us to try and figure out what were the causes of wrongful conviction, and if we could establish what were the contributing causes, perhaps we could work with scientists, do research, and come up with remedies, ways to reduce the risk of people being wrongfully convicted in the future. And it became not only a matter of avoiding wrongful convictions, we realized it was also a matter of public safety. Because in the Gates case, that temporary janitor, who not only committed this brutal murder, went on to commit other acts of violent assault, and in fact was ultimately imprisoned for a vicious stabbing of another woman, crimes which perhaps would not have occurred had the police not fixated on Donald Gates and instead used better investigative tools to identify the real perpetrator. And so we began to think about deconstructing these 330 cases to see if certain patterns emerged, to see if we could establish causes and then come up with remedies. And of course, when you look at the Gates case, it's not very difficult to deconstruct. Number one, you had a forensic scientist at the FBI who exaggerated the probative value of the evidence. And why do I say he did that? Well, I mentioned before that in his initial report, all he said was the hairs were similar. So with things like DNA, the labs have established very elaborate databases with lots and lots of people, so they know what percentage of the population has a particular version of a particular gene. And if you test 13 or 15 different genetic markers, you can multiply all those frequencies, and that's how they develop these numbers like 1 in 5 billion, 1 in a million, or what have you. But you need to have population databases to do that. If all you do is look at two hairs under a microscope and say that given certain characteristics such as color and whether it's straight or curly, or certain microscopic characteristics that appear to be similar, you say they're similar, not only can you not say they're unique, but you even have no idea as to what the probabilistic significance of that is. Are the similarities such that you would expect them to be in 1 in 20 African Americans or 1 in 20,000? They had no idea. And when someone says it's extremely unlikely that it came from anyone else, that's simply a shorthand for having a number. But if you have no databases and no numbers and no scientific evidence at all about how rare or common something is, it's completely scientifically invalid to make statements such as, it's extremely unlikely that it came from another person. So he violated certain scientific principles, and that was one of the contributing factors of Mr. Gates's wrongful conviction. Another one, which is quite obvious, is the police department or the prosecutor's reliance on this paid informant, a person not who was a co-conspirator in the crime, who wants to help himself, but a person who had nothing to do with the crime, who only claims in exchange for money and getting his own serious crimes dismissed, he claims that this man confessed to him. That's a second contributing factor. But there's a third contributing factor, and that's the police. Because it was said at the trial, and it's been said repeatedly by Mr. Gates, that he had never met this informant before. And the first time he had ever seen him in his life was when he stepped into the courtroom and testified to this fictitious confession. Well, where did this informant get the name Gates? It wasn't in the newspapers. It wasn't on a wanted poster. But he was the suspect of the two Homicide Bureau investigators. It's quite likely that it's the two investigators who had a hunch that Mr. Gates was responsible for this crime, gave that name to the informant to make his story seem more plausible and become more compelling when told to a jury. And so we've done that kind of deconstruction with now a few hundred cases. And we have a sense of what the most significant contributing factors are to wrongful convictions in this country. And some of them won't surprise you. 75% of these cases had misidentifications. Eyewitnesses who simply identified an innocent person as the real perpetrator. Why does this happen? It happens in part because police believe that they know who did it, and when they show the lineup or photo array to a witness, there's only one suspect in the array, and then 4 or 5 fillers. Police inadvertently, not with any malice, inadvertently make suggestive remarks to witnesses. What about number 3, Mrs. Smith? Something as innocent as that can change the outcome in identification. And so what's the remedy that we've come up with? It's very simple. Let's make sure that the police officer who runs the identification procedure is not the same police officer who's been investigating the crime. Therefore, when the identification procedure is run, it'll be done blindly. And there won't be a risk of the police officer, albeit well-meaning, saying something inappropriate to the witness to suggest a certain outcome. It's that straightforward. A second major cause of wrongful convictions are false confessions. And that's probably the most counterintuitive of all. I'm sure none of us sitting in this room can imagine that we would ever confess to a crime we didn't commit unless we were tortured, unless a gun was put to our heads. But now that we've seen so many of these false confessions, and there's so much social science research on why people falsely confess, it's no longer as counterintuitive. The research shows that young people, juveniles, are more likely to falsely confess. They get so fed up with the interrogation, they just want it to end. And they're convinced that the physical evidence will set them free, but it doesn't. The research shows that people who have certain mental disabilities or mental illness are more prone to falsely confessing. And sometimes it's just folks who are more compliant, who are more willing to please the person who's interrogating them, who falsely confesses. Be that as it may, 25% of these cases involve people who were stone cold innocent, who knew nothing about the crime, who nevertheless confessed. But what's remarkable about their confessions is when the confessions were used at trial, the prosecutor was able to argue, look at the unusual details in these confessions. Look at the fact that the confession includes details that were never in the press, like Mr. Gates's name. Details about the way the crime was committed that weren't in the press, that weren't divulged in the community. And what we learned from that fact, that all these false confessions have those non-public details in them, is that at some point during the interrogation, police, maybe intentionally, maybe inadvertently, fed those non-public details to the accused. Again, a very simple fix. Let's just record all the interrogations. They're not secret. Let's videotape them. In some jurisdictions, you can videotape it surreptitiously. That's fine, okay? But let's have a neutral, objective record. And so when it's alleged that the accused not only confessed, but disclosed certain non-public details about the crime that only the perpetrator would know, let's find out whether they came from the suspect or whether they originated from the police. And a third major cause, in fact, 50% of those 330 cases involve the misapplication of forensic science. You folks watch CSI and you think they have all these gadgets and they can do all this stuff, and it's just amazing. 2 years ago, they had a panel of laboratory directors from the biggest crime labs in America, and they had them watch several of the CSI shows. And they said approximately 20 to 30% of that which is shown on the program has been invented. The other 70% is pure fiction. Okay? That's the reality. Yet, so many of these people, when they testify about forensic science, because it is beyond the knowledge base of most lay people, can say whatever they want or whatever they feel about the significance of the evidence. And there's no way to check that, because the people in the courtroom who would ordinarily check that are lawyers who are scientifically illiterate, appearing before a judge who's scientifically illiterate, trying to prove their case to 12 lay people on a jury. It's not exactly the best crucible for the validity of that scientific evidence. And we have a fix for that as well. And the fix for that is to get it right before it goes to a courtroom. You know, in this country, if we're talking about clinical science or clinical medicine, there's an FDA out there. You know, whether you like it or not, one thing they do, which is good, is they determine whether a certain pharmaceutical product is ready for the consumer. Has it been adequately validated? Has its reliability been assessed? Are there parameters beyond which it should not be used? And there are scientists who are making that decision based on reams and reams of data. In the criminal justice context, there is no FDA. There's no regulatory body. There's no scientific body that does that. It's supposed to be determined whether it's ready for prime time in the courtroom. Boy, is the courtroom ill-suited for that. And it certainly isn't the equivalent of the FDA. Another cause is the reality that we have miserable defense lawyers for a lot of people in this country. Most of the people charged with violent crime are poor. Most of them are assigned lawyers who are overworked and underpaid, don't have the resources to get experts, don't have the resources to do proper investigations. It's a serious problem. And the problem becomes exacerbated because the US Supreme Court evaluates the quality of that representation if a convicted defendant appeals it using a very famous Supreme Court case known as Strickland v. Washington. And it's what we used to refer to in the courts as the mirror test. If you hold the mirror beneath the nostrils of the lawyer and it fogs up, he's competent. But so many of these lawyers in these wrongful conviction cases were objectively incompetent. And of course, there's the problem of police and prosecutorial misconduct. I mentioned what the police did in the Gates case, or what they appeared to do. But we have a bigger problem. In the law, there's a doctrine known as the Brady Doctrine. And it says if the police come across any evidence at all in their investigation that could be helpful to the defense, that might be exculpatory or bears on reducing the sentence, that they have a legal duty to turn it over to the prosecutor so the prosecutor can turn it over to the defense. The problem is, in most of these cases, either the police or the prosecutor or both engaged in Brady violations. Important exculpatory evidence was buried, wasn't turned over. Years later, it turns up in a police file that should have been disclosed 20 years earlier, but isn't. And one of the problems with that is that it's very difficult to sanction any police or prosecutors who engage in that kind of misconduct. Under all legal doctrines, if you want to sue a police officer who deliberately held back exculpatory evidence, they are cloaked in something called qualified immunity, which makes it that much more difficult to win a lawsuit against them. And prosecutors enjoy something absolutely unique to people who litigate cases. They have absolute immunity. So if in a given case, a prosecutor willfully, maliciously, deliberately withheld exculpatory evidence, that prosecutor is immune from any kind of civil lawsuit. There was a case just a few years ago in Texas of a man who was a manager of a supermarket who was wrongfully convicted of murdering his wife. Eventually, they caught the real perpetrator 25 years later, who was a serial murderer and thief, again through DNA. But it was revealed for the first time after the exoneration that that prosecutor had evidence, compelling evidence, that the crime couldn't have been committed by the husband, that the crime was likely committed by somebody who had committed other crimes in the community, and that the wife's 4-year-old son who was there said to the police when they came in, "Some stranger walked into our house, some monster we've never seen before, and did this to mommy." That statement was suppressed, and the 4-year-old child was taken away, of course, from the father, and so that statement was never revealed. And it was very clear that the prosecutor had done this all intentionally. But he enjoys immunity. He can't be sued for that. Nor can any prosecutor in the United States. And so those are most of the factors, okay, that are contributing to wrongful convictions, at least in our data set. We'd like to get rid of absolute immunity. We'd like to make it easier to have those bad actors sued. But more importantly than being amenable to lawsuit, we really want to change the culture of police and prosecutors. So this notion about it being a sport, you know, where they think to themselves, well, anybody can convict a guilty guy, but convicting someone who really might be innocent, that takes a lot of skill. You want to get rid of that mentality. You want people not to have tunnel vision. So if discordant data comes into their brain during the investigation that doesn't lock into the person who they believe committed the crime, that they'll consider that discordant data. They'll go out and do the extra investigation. And that's going to require a cultural change in law enforcement in this country, one that I think is quite possible. And the last contributing factor, and I saved it for last because it's the only one that we don't have any recommendations on how to fix, and that factor is race. And our data is quite interesting in this regard. Beginning in the early 1980s, the Department of Justice began keeping data on sexual assaults in America, reported sexual assaults. And it turned out that most sexual assaults occurred within a race. Black men assaulting black women, white men assaulting white women, Hispanic men assaulting Hispanic women. Only about 10 to 11% of all sexual assaults are cross-racial. Yet, in our database of exonerees, 70% of the wrongfully convicted are non-white. And 55% are black men who were wrongfully convicted of assaulting or killing white women. That's 5 times what the Department of Justice data says it should be. It's a serious problem and one that we as a nation will have to address. But the reason I wanted to tell you about the Gates story is sometimes we get a case that creates a paradigm shift, where things happen that were never considered capable of being realizing. And Donald Gates is one of those cases. Because when it first was revealed that he was innocent, we talked to the FBI about the testimony of the hair microscopist, who was a sworn agent of the Bureau, and talked about how his testimony was objectively invalid, even by their own standards. And they concluded, well, the guy who testified in that case must be just a rogue agent, a bad apple, and we're just going to let it go, we're not going to do anything. But in 2010, in 2011, and then in 2012, 3 more people were exonerated in the District of Columbia, where the primary evidence used to convict them had been hair microscopy, presented by not the same agent, but by 3 additional agents of the FBI. And when you looked at the testimony in those cases, it was the same kind of scientifically invalid testimony given in Mr. Gates's case. And so we at the Innocence Project reached out to the FBI, and we agreed to enter into a collaboration with them and with the National Association of Criminal Defense Lawyers to get the FBI to do a reanalysis of old cases, at least look at the transcripts in old cases where FBI agents said that a person was a match, where there was an inclusion, and make an assessment as to whether their testimony was within the appropriate parameters of scientific testimony or whether it exceeded it. And when they went back and they looked, they found 2,500 cases that needed to be re-examined. And in May of this year, just a few months ago, the FBI released their results on the first 300 trial transcripts that they re-examined. And according to the FBI's own investigation, in 96% of those trial transcripts, the FBI agents working in their laboratory provided scientifically invalid testimony, made errors which exaggerated the probative value of the evidence, and misled the fact finder. 96% of the time. And it wasn't a situation of one bad apple or two bad apples. Of the 28 agents who were hair examiners at the FBI, 26 of them included these scientific errors, these gross exaggerations in their testimony at trials. Now, no one is saying that all these people are innocent. Some of them may be. I mean, right now we have 74 cases in America of our 330 where hair microscopy was used to convict those people, and they've now been exonerated by DNA. But our Constitution, that wonderful document, guarantees that every person in this country will get a fair trial. And part of getting a fair trial means that prosecution witnesses cannot put their thumb on the scales of justice. Because when they do that, the Constitution is undermined, this nation's integrity and sense of justice is undermined, and we cannot allow that to happen. And so that's why the FBI, for the first time, has acknowledged a duty to correct and a duty to notify all the people who may have been affected by the erroneous work of their agents for more than 2 decades. And I would point out that one of the people who most effectively now is holding the FBI's feet to the fire is your own U.S. Senator, Senator Grassley. He is the chairman of the Senate Judiciary Committee, and in his oversight responsibility, he has been bringing the FBI before him and before other members of the committee and holding them accountable for this disgraceful activity that went on uncorrected for more than 2 decades. He's really been quite important in this corrective action. And you might ask yourself, how did this happen in the first place? Well, the way it happened, and I alluded to it before, is that, in DNA, as opposed to so many of these other disciplines, whether there's something like hair or fingerprints or bite marks or bullet comparisons, DNA did not start out as a tool of law enforcement. DNA started out in the medical profession. And before it was ever used in a single criminal case, hundreds of millions of dollars was spent on basic research, applied research. There were thousands of peer-reviewed articles. Efforts were made to refute the research and the findings. All of that normal scientific process with fundamental scientific principles was engaged in by the scientific community in this country and in other countries. But think about it. Unlike DNA, which has a medical application, what medical application is there for fingerprints, or for a microscopic hair comparison, or for a bite mark comparison? None. Absolutely none. And so the people who developed those other techniques were not people steeped in the scientific tradition. They were people primarily who worked for law enforcement or worked with law enforcement. And I'm not holding it against them. But the reality is that those people didn't understand the significance of basic research, applied research, extensive peer review writing that can be debated in the community. None of that happened. They were content with, instead of having the research and peer-reviewed articles, simply introducing the evidence in court. And if a judge accepted it, it was valid. That's a bad situation. It's a recipe for disaster. And that's how so many of these other disciplines, came into court. And it's only because of the DNA exonerations that we now know how invalid they were, how unreliable they were, how the scientists grossly exaggerated their probative value in case after case. But we can fix it. We can start doing basic research in these areas. The president has set up a commission on forensic science, to try and make recommendations to science agencies, to Homeland Security, to the Department of Defense, to the Attorney General, to all kinds of people, to get them involved in a collaborative process to make forensic science much more rigorous. And I think they will succeed. And there will be the kind of culture change that we want for law enforcement, we'll begin to see it in crime labs. It doesn't happen overnight. I remember when I got involved in a medical center, I'm on the board of a medical school in New York City, 20 years ago, when we wanted to investigate a mishap that happened in the OR, we couldn't get a single doctor to come in and talk about it. They were petrified that they would be disciplined, that they would be sued, that all these terrible things would happen to them. And then by changing the culture, we got the doctors to understand, if you come in and tell us that something went wrong, we will celebrate you because we will do a root cause analysis. We will find out what went wrong and how we can tweak the procedures in the OR to make it less likely that it's going to happen again, and you will be part of the process to save lives. Now, that change in consciousness doesn't occur overnight. It took many, many years. But now when I go to those meetings, the nurses, the doctors, the technicians come forward, they talk about these problems candidly, and the medical centers are better off for it. And when you think about the kind of changes we need federally, you should also consider the kind of changes that are happening right here on the ground in Iowa. And it's really extraordinary. I thought it was, people were saying, oh, this was a conspiracy, you planned this whole thing. But I woke up this morning in my hotel room, and the lead story on NPR mentioned that your governor, Governor Branstad, announced yesterday, number one, the creation of a wrongful conviction unit in your state public defender office, which is really a phenomenal thing, and also announced that he was authorizing a review of all the hair cases here in Iowa. And that's important. And the reason that's important is when you realize that 26 out of 28 hair examiners were all giving erroneous testimony, you then realize that all the state and local examiners, or most of them anyway, were trained in how to testify during a training program given by the FBI hair unit. And so the kinds of problems we see in testimony that came from the FBI, we now see in most of the other exonerations involving hair, where state and local lab people testified. And so, I think the governor deserves a lot of credit for this, because he's really trying to get ahead of the curve by setting it up. They've already identified 100 cases in Iowa where hair microscopy played a role. No one knows, whether they did it wrong in those cases or did it right, but they're going to roll up their sleeves and investigate them and look at the transcripts, see if the biological evidence still exists, and do something about it. Because just because it happened a decade ago doesn't mean you can turn a blind eye. Getting it right is very important. And like I said, in all the cases, or in many of the cases where we got it right, we also found out who the real perpetrator was, who had eluded justice for all these years. And so it's really quite something that this is happening here in Iowa right now. And it's quite something that Senator Grassley has done what he's done in Washington to try and bring some oversight and reliability to the forensic community. And you should be pleased with that. But the job isn't done here in Iowa either, because two of the most important reforms that I mentioned earlier, which means changing the procedures utilized for conducting identification procedures with witnesses and recording interrogations, neither of those are mandatory in Iowa. The governor has agreed to at least look at some of these problems involving eyewitness identification and false confessions with a working group that he set up. But what you folks need to do is to talk to your legislators, to communicate with the governor and tell the governor that it's important that these things get fixed, that everybody wins. It's not about being soft on crime. It's about being strong on crime and making sure that the right person is apprehended. That's what these reforms are about, and I'm sure that all of you can become engaged in it. And for those of you who are students here at Drake, there is an Iowa Innocence Project. There is this new division at the Iowa Public Defender. They need your help. There are things that you can do to make this whole undertaking more robust. And why is it important? It's important because when we started this movement 25 years ago, it was just one law school clinic in New York. And that's now grown into a civil rights movement of more than 40 different innocence projects across this country. It's actually blossomed into a human rights movement with 15 to 20 projects in countries on 4 different continents now, because people understand the importance of the rule of law. They understand that we have to overcome certain cognitive biases and try and use evidence that's empirically based. They understand, and it's our goal, to create a system where investigations of crime and adjudications are predicated on the most robust scientific evidence. And if we do that, and it's a goal that we can accomplish, it's a goal that will be replicated in countries all over the world, and we'll be the leader in it. If we do that, we will have a much more reliable system, and ultimately one that we can be proud of calling a just system. Thank you very much. Thank you. I think the plan is for questions, and I think there are 2 lines and 2 mics. So I'd love to engage you all in this, because I think you have a lot to offer. I can't imagine that this group is speechless.
All right, my question, thank you for being here. My question is about the first instance that you brought up. You said that after they did the DNA testing and exoneration, they were able to find another match in the system. Is this something that you see a lot throughout cases, or was that more of an isolated circumstance?
So of the 333 people who have been exonerated now through post-conviction DNA testing, we've been able to identify the real perpetrator in approximately 1/2 of those cases. And generally that person has been identified by checking the profile of the perpetrator against the convicted offender database. Other times, we actually did the investigation ourselves, reinvestigated the case, found the most likely suspect, got a DNA sample from him, matched it to the evidence from the crime scene, and then worked with law enforcement to have that person apprehended and prosecuted.
Thank you for your talk. It was excellent. I have a question about the person who is exonerated. I've heard so many stories about, after their entire life has been ruined, and sometimes that of their entire family and children. How much is each year of their imprisonment worth in dollars after they get out?
It's kind of like those Visa ads, it's priceless. But all kidding aside, you can't put a dollar amount on that. Most of the people who have been exonerated have never received any compensation at all. We believe that states and the federal government have not just a legal responsibility, but a moral responsibility. That even if you can't show that there was any kind of legal misconduct on the part of the state, if they put a person in their prison who turned out to be stone cold innocent for 27 years, like Mr. Gates was, you have a moral obligation to help that person out financially, to help that person out with therapy, to give that person vocational skills, medical assistance, and do what you can. It's really interesting. These guys, they sort of blow my mind every time we walk one of them out of prison. Because, I don't know about you, but if I was wrongly convicted and no one believed me and they locked me up in one of these hellholes, I'd lose my mind, okay? Or I might hurt somebody or hurt myself. What's extraordinary is almost every single one of them, when they leave prison, they are at peace with themselves. They are generally very spiritual. They have come to terms with their situation. They believe that there was some meaning beyond what you see on the surface to why this all happened. They have forgiven prosecutors and police and other people who made errors or worse in the cases. But they would expect and hope that they would get help. and they don't. And so, an exoneree like Mr. Gates goes out carrying the newspaper clipping from the Washington Post about his exoneration to a prospective employer and says, look, I was convicted of something I didn't do, and I spent all these years in prison. I really want this job. And the employer says, I feel terrible for you, but you have a 27-year black hole in your employment history. I'm not going to hire you. And I'm not going to rent you an apartment, and I'm not going to give you a loan. And human relationships become very, very difficult. And so these people are constantly facing all kinds of struggles, and we're trying to help them, but it's not easy.
Thank you.
I believe that President Obama would like to leave a justice reform legacy. My question is, what and how can the Innocence Project help him get practices, procedures, and policies changed? And are there any laws that you see in the next 2 years that the Innocence Project will help change?
So most immediately, we think it would serve the president quite well if he sat down with a dozen or so exonerees and talked to them about their cases, about their lawyers, about their trials, about their experiences in prison, and the difficulties they've had since they got out. There's no question that that kind of frank communication would be extremely useful to the president in developing policy. Beyond that, there is legislation that's been introduced in Congress that would transform crime laboratories to make sure that only validated techniques are used in criminal cases. But as you all know, getting legislation passed through this Congress is, I have a better chance of hitting 5 homers in the playoffs. It's not going to happen very easily. So legislation is something we want, but we're not getting right now. But what the executive branch can do with its executive power is do a lot of things at the federal level with the expectation that the states will want to replicate what they're doing. And that could be with forensic science. They've already decided to do it with recording interrogations. We've been working to try and lobby the FBI, the DEA, and other federal law enforcement agencies to record interrogations for a decade. Last summer, they finally announced that that's going to be a presumptive requirement in all interrogations that are custodial with any suspect. So that's a great step forward, and hopefully the few states that haven't done that yet across the board, including Iowa, will. Next question.
Professor David R. Rowe talked about how 8 out of 10 death row inmates have the same upbringing and exposure to the juvenile legal system, and it's a cultural problem. Do you believe that a shift in the way we deal with petty crimes and juvenile law would shift the way more heinous crimes are prosecuted and convicted?
I'm actually not qualified to answer that question. I'm not a scientist or an anthropologist or a sociologist or a psychologist. What I can tell you, which is pretty interesting, is we deal with people who are wrongly convicted of the most serious crimes, homicides, sexual assaults, that kind of thing. But there's no question in our criminal justice system that there are going to be far many more innocent people wrongly convicted of petty crimes and misdemeanors simply because people just can't put up with it anymore and plead guilty to some minor offense, which gives them a record for life just to go on with their lives, with their work. We're not sure how to address that problem, but it certainly needs to be addressed. And in terms of juveniles, I mean, we do what we can to leverage our data. I mentioned before that a disproportionate number of the false confession cases involved 14, 15, and 16-year-old boys who, because of the severity of offense, were treated as adults. So certainly that's a factor in that context.
Thank you for being here tonight. You mentioned briefly in your remarks the role that race plays in some of the cases that you've worked with. Recent months, movements like the Black Lives Matter movement have raised this to the front of national discourse. I'm wondering if you have any sort of insight into who's doing good work out there regarding the role that race plays in this, or maybe some of the next efforts that need to be done in that.
Yeah, I don't know how to answer that question either. I can only tell you that it's obviously important that it become part of the public dialogue. That's a good thing. One of the most recent pieces of data that we've sort of discovered, which is very alarming, that we have 330 exonerations through DNA. There are folks at the University of Michigan who have a registry of people who were exonerated without DNA. And in the last 25 years, they've identified 1,600 people who fit into that category. And they did a comparison of all the white people who are exonerated versus the black people who are exonerated. And they found that on average, the black people all spent between 2 and 3 years longer in prison before they were exonerated. So when we start looking at all this data, we see more and more indicia of this kind of racial problem. And I think it's our role to simply bring it to people's attention and try and perpetuate that dialogue and hope that good things come of it. Yes?
2 parts to my question. First is there any data collected on prisoners that have been put to death and later discovered through DNA evidence to not have committed the crime? And then the second part has to do with systematic biases. You mentioned prosecutors, but I'm wondering about judges, and Lucerne County is a great example of something that went on for Kids for Cash for, I think it was 10 to 20 years. Right. So what thoughts might you have on how to address those types of systemic abuses?
The first one on the death penalty, what was that again?
Collecting data on people who have been put to death.
Yeah. So we know, of a couple of people who we believe were put to death who were factually innocent, but they aren't DNA cases. I mentioned before that it's only a small minority of the cases where there's DNA. And there've been 18 people exonerated, not because the system works, but because after they exhausted all of their appeals and all of their collateral habeas corpus attacks, there was a serendipitous intervention of DNA testing which proved they were innocent. In the case of one client I represented in Virginia, 9 days before his execution. Totally serendipitous. In the case of another person we represented in Oklahoma, 5 days before his execution. So what's the likelihood if we did those interventions that other people fell through the cracks and were executed? Probably pretty darn good. The other problem is we had a case in Texas where a person was sentenced to be executed, and I was negotiating with the district attorney to get DNA testing. And he finally said, no, we're going to execute him, but I'll let you do the DNA testing after the execution. And so the execution occurred, and a week later I called, and he said, I'm sorry, but we changed our mind. So it's very difficult to get, the silver bullet that you're describing, okay? I think we'll get there, but there have been so many people exonerated from death row already that it's not much of a leap to think that innocent people have clearly been executed in this country. As for judges, there's no question that judges' own cognitive biases and other biases play a role in it. And I distinguish the cognitive bias because it's one that we're not aware of, that we have anyway. I did an analysis that was published some years ago on when people challenge scientific evidence that's being proffered by the prosecution as opposed to the defense, and it gets challenged by the other side, what happens? And what we found is that overwhelmingly, when the prosecution proffers novel scientific evidence and the defense challenges it, the judges routinely rule that it's admissible. When the defense proffers it and the prosecution challenges it, it's routinely rejected. Now flip that into the civil world, where large companies are fighting over great sums of money. When plaintiffs introduce it in the civil context, the evidence is most frequently suppressed. And when the defendants, generally the large corporations, introduce it, and it's challenged by the plaintiffs, it is almost always admitted. And we finally did a little experiment, and it's going to be expanded into a much larger experiment. Someone else did it. They took a forensic discipline that has crossover appeal, criminal and civil, arson. So if there's arson, the insurance companies are going to get involved, and also the criminal justice system is going to get involved. And a relatively neutral report was written and given to some judges. And the judges who said it was being offered, okay, by the prosecution in the criminal case tended to admit it. The same judges who received the same report in a civil case where it was being offered by the person who was trying to get his insurance money and use the same report for that purpose, it was kept out of evidence. So there is that kind of cognitive bias. It exists in many aspects of the criminal justice system, but probably the best way to deal with that is through greater education of judges. I mean, for instance, judges don't understand science, yet they're asked to make important rulings on the admissibility of scientific evidence. So we need more judicial training in this country. We need a cultural change for them also to try and work around the cognitive biases. But all those fixes are going to take time.
Yes, sir. I want to say thank you for coming tonight. Your lecture was wonderful. I'm currently an investigator with our local police department. I need to preface this by saying I do not speak for them. But I, previous to this position, was a genetic researcher for years, and I do understand some of the difficulties. What is the possibility of having a neutral investigative body or oversight body that both the defense and the prosecution have access to review both the probative value and the admissibility of evidence used in courts?
So are you talking about scientific evidence or non-scientific evidence?
Scientific evidence.
So the problem, I don't know whether neutrality exists. And what you're hoping for with scientific evidence, as opposed to an eyewitness, as opposed to an informant, is you're trying to look at something that you believe is objective, is neutral, intrinsically, right?
Right.
And so the issue should not be duked out in a courtroom amongst competing laboratories. Hopefully, we will only use scientific evidence whose validity and reliability has been well demonstrated long before it ever got to any laboratory. And that way, when the laboratories use it, and the people testify, and they follow standards about what the parameters of their testimony should be, we won't have to have dueling laboratories. Well, if my kid's sick and I have her tested for strep throat, I don't worry that, my God, I'm using this laboratory as opposed to a laboratory in Topeka, and they're going to get different results. I have confidence in that. There's a consistency. There's reproducibility. I want the same consistency and reproducibility in forensic science. Yes?
Sir, are you aware of the CPS programs of state departments that are usually human services? And if so, does the totally closed legal process in those programs alarm you in any way?
I apologize, but I'm actually not familiar with it at all.
It's Child Protective Services.
Oh.
It was the Mondale, Clinton came in, Clinton signed it into law.
Okay. So what I'm most concerned with, and it's not just the so-called bench sciences that are used in forensics, but I'm certainly very much concerned with the use of psychology in criminal justice. That there are people whose sole job is to determine whether or not children are truthful or children are lying when they make certain allegations. For those of you who are parents, you realize that that's a very difficult undertaking. But I've talked to some of these experts in child abuse situations who work actually at our own medical center, and they've never heard an allegation that wasn't true, and that defies credulity. what you would like to see in psychology, particularly when it's used to evaluate credibility or when it's used to try and predict future dangerousness, is you would like to see the same amount of rigor in those disciplines that we have in DNA testing. And unless and until you have that degree of validity and reliability, that kind of evidence should not be introduced. Instead, they should rely on other types of evidence to adjudicate those cases. Yes?
I'm very curious about how often you find the wrongfully accused are also accused of legitimately accused of other crimes or convicted, or how often they are completely innocent. And what you find with the correlation there is in the types of people who are wrongfully accused.
Well, I mean, certainly, if you look at Gates just as an example, there's no question, that after he was discharged from the armed services, he developed a drinking problem, and he had a couple of run-ins with the law. He stole a man's briefcase at the Smithsonian Museum. There's no question that if you have even that kind of more modest interaction with the criminal justice system, you are more vulnerable for being wrongfully convicted. Obviously, if he hadn't had minor run-ins with the law, his photograph wouldn't be in the mug book. Okay, they couldn't have picked him. So certainly that occurs. But we've had plenty of people who were wrongfully convicted who had never been arrested in their lives. Not at all. We had a client who they taped on the Iowa NPR show this morning from Virginia, who was the high school star of the Hanover, Virginia baseball team. He was African American. He was dating a young white woman. And a white woman was attacked on her way home from the mall and by a black man. And during the course of the attack, he said to her, "You ain't so special. I've had me white women before." So when the victim went to the sheriff's department to report the crime, the sheriff thought to himself, "Wow, do I know any black men in Hanover who are going out with white women?" And the only one he could think of was Marvin Anderson. He didn't know any others. So Marvin had never been arrested even for jaywalking in his life. And so he went to Marvin's place of employment and got his employment identification card, which is a color ID card. And he created a photo array of 6 black and white mugshots of offenders, those are the fillers, and Marvin's color employment identification card. And of course, she picked out Marvin. And it was 22 years later that the real perpetrator was identified. And what's most unusual is that real perpetrator was actually one of the 6 fillers. He was one of the black and white photographs, but she didn't identify him because, you zoom in on the only color photo in the whole set. It's that simple. So yeah, there's a correlation. Sometimes there's not a correlation. I don't think we have enough data yet that we can draw those inferences, but certainly you're more vulnerable.
Right.
Yes.
Thank you, sir.
Hi there. My question is about sourcing. So how do you guys get sources of clients and cases? So how do you choose which courses that you're going to choose to pursue, and how do those courses come to you?
So we get, oh my God, I think at this point in time we're averaging about 1,000 new letters a month, maybe 800 new letters a month from prisoners around the country. By the way, my advice to people in Iowa is that you write to the Iowa Innocence Project and you write to the Iowa State Public Defender that now has a wrongful conviction center. They now have the capacity to investigate claims here in Iowa. I don't know how much Iowa really had that capacity before, but we expect great things here. But what we do is we can't rely in screening those cases on the normal criteria, because we've had exonerations in cases where there were 4 eyewitnesses, where there were confessions, where there was 2 different lab people saying it's a match to the defendant. So we have very simple criteria. Did the person claim not to be the perpetrator at trial? Okay. or did the person claim that before he pled guilty under the threat of a more severe sentence? Was biological evidence collected in the original investigation? And if we tested that biological evidence using state-of-the-art DNA testing, could it be dispositive on the question of innocence? So if you meet those criteria, we'll take your case. Now, on average, it can be 4 years from the time we take a case till we actually assign it to a lawyer because of the backlog we have. And that's why it's all the more important that for people in Iowa to get involved with the state project here and the state public defender. It's also the case that very often in those intervening years that the key biological evidence is either lost or destroyed, and you can't do the testing. And so one of the things that you need to do here as well as every place else is have a very uniform system, not only of preservation of evidence, but a means of accessing that evidence. And by the way, that's not just good for defendants who want to prove they're innocent. That also helps prosecutors who want to reopen cold cases. If you can't find the evidence from 5 or 10 years ago, you're out of luck. Yes?
This last spring, I had the pleasure of meeting Ricky Jackson, who talked about his dealings with the Ohio Innocence Project. My question is whether you have any plans or a time frame for expansion of the Innocence Project into areas where they currently don't have any jurisdiction.
So, that's a big problem. I said we have more than 40 projects now around the country, but there are some states where there is no project. We don't have a project in Alabama, for instance. And it's funny. We had a case where we were trying to get DNA testing about 2 years ago in Alabama, and we couldn't get it under Alabama law. So I was trying to convince the state attorney general, and he said, "Well, you don't have any exonerations in Alabama." I said, "That's true." He said, "Well, don't you realize that the reason you don't have exonerations in Alabama is because our system of criminal justice is far superior to that of the other 49 states." So, clearly Alabama is an example of a place where we would like to do a lot more. But you have to understand that there are states in this country where prisoners do not have access to law libraries, where their ability to communicate with lawyers from innocence projects, is restricted. I made a visit to Parchment Prison in Mississippi and met people who had been in prison for 40 years. They went in at age 16, pleading guilty to serious felonies at their arraignments after a 5-minute conversation with a lawyer. But all the evidence has been lost or destroyed in the intervening years. We need to do more in Mississippi. And hopefully we'll be able to do that. And even if we can't get local projects that can do it rigorously and vigorously, then we'll expand our project to make sure that task is taken on. Thank you. Yes?
First, thank you, sir, to being tonight. And I know it's kind of weird, the young high school exchange students sit over here and ask questions. But anyway, my question is that what do you think will be the cost if we change these systems in the 3, 4, 5 years? And do you think this cost is acceptable in these 3, 4, 5 years? Or you think we'll have to take longer time to change this system?
Well, change is slow, okay? It takes time. I don't expect to accomplish all these goals in the next 3 to 5 years. I think some of them are much more readily achievable than others. But the reason why the expense is well worth it is because it's not just a matter of getting the innocent out of prison, it's a matter of public safety. We've shown so many times now that when you get the wrong guy, the real bad guy remains at liberty to prey on other innocent victims. And so, do you know how much it costs, how much it costs the state when you have an unsolved murder? We want those murders to be solved, and to be solved reliably. So it's worth the investment. Do you know how much it costs to house a prisoner in a state penitentiary? Why have somebody there who's innocent? The state's going to save money. Why would you want to videotape interrogations? Well, the police should want to videotape interrogations and shouldn't resist it, Because next time a defendant says, I never said that in a courtroom, all the witness has to do is press the play button, and the jury will hear the truth. So all these reforms are a win-win. So it's not a financial sacrifice, it's a financial victory.
Thank you, sir.
Okay? Thank you all. Thanks.